Hello. Good morning, everyone. Welcome. As you come in, say hi. If this is your first time, definitely say hi in the comment box. Let us know where you are tuning in from. I have a good topic for you guys today. So I'm just going to wait for some people to tune in. Good morning, YouTube. Good morning, Facebook. Good morning, Instagram. And if you're tuning in for the first time, my name is Aisha Chidole. I'm an immigration attorney in Orlando, Florida area, but I represent clients all over the United States with their family immigration matter. It doesn't matter where you're located. I represent clients in all 50 states, so it doesn't really matter. My phone number here is 407-995-6567. You can also send us a text on WhatsApp. That's 404-333-8751. I do this live because I love to answer your questions and talk about topics that, I think are interesting to you guys. So let me know where you're tuning in from. Hello, Diablog. Hi, hello, OJ Blazin. Thank you on Instagram. Good morning, Kosi on Facebook. Good morning, Favorite Carrie on Facebook. Thank you guys all for tuning in. So today I want to talk about getting your green card through your child or getting your green card through your parent when neither of these people are able to petition for you or choose to petition for you. So let's talk about children. So a lot of times, you might have a parent of yours who marries somebody, and the person files a petition for your parent and is not willing to file a petition for you. And, that person treats you poorly. That person is mean to you. That person curses you out. That person, calls you all kinds of names, or makes, your own parent choose between you and them. If you have that situation, you could potentially qualify to self-petition by yourself as a child. So some of the things that we look at when oh, you guys can hear me on Instagram? Can you guys hear me on Facebook? Oh, all right. Can you tell me I'm Wealthy Sumbi? Can you, if you're on Instagram, can you hear me? Let me know. And if you're on Facebook, let me know if you can hear me, because somebody's saying they can't hear me. So I don't know if that's my volume or am I on mute? Anyway, let me know in the comment box. Let me know. Okay, you guys can hear me on Facebook. Well, Instagram, I'm not sure what's going on. If you can hear me, comment, or you can hop onto Facebook and join us on Facebook. Oh, okay, so you can hear me. So I'm Wealthy. It might just be your audio. That's the problem. As I was saying, so some of the things, that would allow you to qualify as a child or a stepchild to self-petition by yourself without the help of your stepfather or stepmother or even your own parent is one, your parent had to have married that step-parent before you turn the age of 18. This is really critical, because if they married them after you turn 18, you wouldn't qualify, and that step-parent wouldn't even qualify to petition for you. So it has to happen. The marriage has to have happened before you turned 18. Also, you have to be able to document the abuse or the extreme cruelty that you've experienced with that step-parent or with your own parent. Remember, it's not only step-parents, it could be your own parents that's a U.S. citizen or a green card, down to you having lived with them, showing that at some point you lived with them. Different examples could be them not letting you, making it hard for you to get around to school as a way to punish you, or taking your computer away from you where you can't do your homework, calling you all sorts of names, making you go without food, being physically abusive towards you, and all those things. Like, if those things happen, even if you came into the country without inspection, you cross the border, you don't have any papers at all, you can be eligible to file for a green card on your own and get a 10-year green card based on the way that that parent or that step parent has treated you. And then on the parental side, similar to the child side, this applies to parents who have US citizen children who are 21 years or older. So they can be green card holders. They have to be US citizens. If their parents, if their children are 21 years old and they're US citizens, they can qualify to self-petition if they have a child that is extremely cruel to them. A lot of times with parents, we as parents, we are very we're very territorial about our kids, and sometimes it's hard to accept that your child is maybe not on their best behavior. And I see all your questions, guys. I'm going to answer them once I finish talking about this. So definitely feel free to put your question in the comment box. I'll try to get to your questions. As I was saying, with parents, sometimes it's hard, acknowledging or accepting that, your child is bad or your child has a bad behavior, because sometimes we feel it's a reflection on us, as parents, or what one has done as a parent. But the thing is, you cannot blame yourself for each person's decision in life, because at the end of the day, people have free will. So examples of that are, if you have a son or a daughter that's like rogue, cutting classes, getting in your face when you have arguments, cursing you out, not respectful to you, making you feel less than, making fun of you because, maybe English is not your first language. Maybe, you don't really know how to live a 21st century life, depending on if you came from a third world country and you're not used to certain things here, that's really toxic to you. Sometimes you have kids that, will threaten suicide, as a way to make their parents bend to their will. Like, I'm just going to kill myself, like, or whatever it is. And those things cause a lot of emotional trauma, for any parent. So, if you're experiencing that with your child, and that child is over the age of 21, you potentially could qualify to self-petition by yourself and get a 10-year green card. Now, when you apply for VAWA, and this applies to both parents, children, and spouses, you don't need that partner in the application process at all. You don't need them to sponsor you at all. They don't need to do any financial affidavit of support. This is a confidential process. Your child, if you're filing against your child, this does not affect your child. There are strict laws that govern victims' rights where they're not allowed to disclose that to their child, and that they're not allowed to penalize your child for anything. So, because, as I said, people stay and suffer in those situations because it's their child and like, oh, I don't want to say anything bad about my child, but they're suffering. But your child is not going to suffer. This does not affect your child. This is about you, the immigrant, and protecting you, as an immigrant and getting your paperwork. The same thing applies, if you're a child that's being abused, this does not affect your parent. And, they can be dealing with whatever they're dealing with, but this is about you getting your green card as a victim of extreme cruelty. So that's kind of how the parent and child situation works. And similar to a marriage base, you want to be able to document the different types of abuses you've experienced, and the different types of extreme cruelty, whether it be physical, psychological, emotional, verbal cruelty, if you've been molested, any of all those things. Those are all credible evidence, and having a statement, about what you've experienced, helps with your case. So that's that on that. I'm going to take some questions. So put your questions in the comment box, and I'm going to try and answer them and say hi to everybody. Guys, remember, if this is your first time tuning in, please definitely subscribe on YouTube, like us on Facebook. Actually, share this video. We're like 20 followers away from having 7,000 followers. So I'd appreciate it if you share this, in your timeline so people can follow us and we can have 7,000, let's see if we get to 20 more today. Okay, so let's see. So Delhi says, Miss, my I-751 joint petition got denied. What can I do now? My wife is giving me problems right now. Well, you need to call me right now. You need to call me right now. Let us qualify you and see if you qualify to self-petition by yourself. So denial does not mean it's the end of the world. You might still be eligible to submit a new application on your own independently, but you want to act fast before you go into removal proceedings. So call me 407-995-6567, and then we can see if you qualify for one of the waiver exceptions, okay? Tessa says, good morning. Good morning, Tessa. Where are you tuning in from? Paulette says, good morning. Hi, Paulette. How are you? Let's see, on TikTok, on Instagram. Good morning from Virginia. So do you guys have any other questions for me? If you don't have any other questions, this is going to be a short one since I already talked about my topic. Let me give you guys about a minute to type it in there. Okay, so Paulette says, how long after the parent gets her green card will the child be able to come into the country? It really depends. So it depends on whether you petition for your child, or not. If you petition for your child and your child is under 21, there's right now an immediate visa available. So if you're lucky, when you get approved, visa is immediately available. And if visa is immediately available, then it's the same timeline as a marriage base, which right now is anywhere from 12 to 18 months, depending on the country you're from. If a visa is not available at the time you get your green card approved, then you have to wait for a visa to be available. Once a visa is available, then they can do the consular processing for the child, and then the child can then come in here. So that's how that works. Good morning, Tiffany from Bahamas. Thank you for tuning in. So somebody asked, what are the risks associated with traveling out of the U.S. with a VAWA parole? So what you're actually trying to say is, what are the risks of traveling with advanced parole, which is a travel permit, if you live outside the United, if you filed a VAWA petition? Well, so the risk of everything is that, you might get a hard time with Customs and Border Patrol. If you have any removal proceeding and you accidentally got a travel permit, definitely do not travel outside the country. If you don't have that, the risk is as good as any other one. You technically can travel. As I always say, just try not to stay a long time, just because if they call you for something or you have to go to biometrics, you don't want to be out of the country and not able to get into the country. I think a lot of people are iffy now because of what happened last year with the pandemic, and then so many people got stuck. So just make sure that when you're planning that trip outside, that you're not planning to be out for a long time. But generally, a travel permit does allow you to travel outside the U.S. and come back. And many of our clients do it without an issue. Paulette says, I'm doing VAWA, you're my lawyer. Oh, hi, Paulette. See, so many people have the same names, so I don't know. But yeah, so, the answer is still the same. If you get approved, when you get approved as a VAWA candidate, your process is a little different. When you get approved as a VAWA candidate for a green card, if there were children listed on your prima facie determination letter, when you get approved for VAWA, they get approved for VAWA. However, you're still going to file what we call an I-824 when your process is over, to allow USCIS to transfer, to basically open a case for the child. And then they open a case for the child. That takes a couple of months, like 7 months, and then they send it over to whatever country that child is in. And when they send it to whatever country that child is in, you still have to go through NVC. NVC is National Visa Center, where we fill out the application. For anybody outside of the United States, they still fill out their immigrant visa, and things of that nature. And once they fill that out, they schedule them for an interview. So timeline could still be that long, anywhere from 12 to 18 months. It just really depends, again, on what is available. If it's through VAWA, at least they'll capture the priority date. So the priority date will be captured, and likely you might not have to wait for a visa to be available. So it just really depends. It's one of those things where until the situation presents itself as a green card holder, you have to check at that time because, the visa availability changes every month. Okay. Let's see on Instagram. This person says, it's nice always listening to you, Chi. So my name is not actually Chi. My name is Aisha. Many people think my name is Chidole. That's my last name. My name is actually Aisha, so it's not Chi. But thank you for tuning in. See, somebody just said good morning, Chi again. Kazim, my name is Aisha, not Chi, but thank you for tuning in. Do you guys have any other questions before I jump off? Somebody on Instagram wants to do, what is their request? I don't know how to do it. Like, how do I allow somebody to tune in via video? I don't know how to do it. So let's see. This person says, with a marriage-based interview, does your husband, who's a petitioner, have to go to the interview with his stepkids ages 11 and 16? So are you asking if he has to go to the interview with the children for the marriage-based interview, or is the interview for the children? If the interview is for you, the wife, he has to go with you. If he's a petitioner petitioning for the children, he has to go with them. The petitioner always goes to the interview with their beneficiary if they're within the same country. Okay. So Favorite Carrie says, do you have to wait for a visa to be available when you're married to a U.S. citizen under VAWA? No, you don't have to wait for a visa to be available because U.S. citizens are considered immediate relatives. So there's an unlimited visa and stuff. Okay. Somebody asked, what is the difference between the received date and the priority date? Received date is the date that USCIS receives that documentation that you submitted, and your priority date is the date that they process it. So what it means is, let's say they received your stuff on June 1st, and then they just put your priority date as June 3rd or something like that, 2021. When you're in a family preference category, they list it based on priority date. So they may say, we're processing cases from May 2021. So what that means is that people whose priority date says May 2021, that's where they're processing. So it means that they're 1 month out from getting to you, or a couple months out or whatever from getting to you. So your priority date is what you use to determine when a visa will be available to you. And this only applies to people in family preference categories like, green card holders or people that are filing for their children that are over the age of 21 and stuff like that. Bill says, good morning. I live in Minnesota. I have a question. I did my application back in February, but until this time I have gotten no response. So do you mean that you've not received a filing receipt? Is that what you mean? If you've not received a filing receipt, that's a problem. So you might want to see if your files actually got there. If you've received a filing receipt, I don't know what kind of case you filed, but that's not extraordinary time that you're waiting. That sounds normal. If you've gotten your filing receipt, you're just at this point need to be waiting. Okay. Somebody says, what if the children are here in the United States? So if your children are here in the United States and you're married to a U.S. citizen, well, what is your question actually? Let me just give you a scenario. I'm not sure if that's your question, but if your children are here in the United States and you're married to a U.S. citizen, there's no wait time. You can actually apply at the same time as you're applying for yourself. So if you qualify for VAWA, you can apply for your children at the same time, as you're applying for yourself. If you don't qualify for VAWA and you're applying based on marriage, you can apply for your children at the same time as you're applying for yourself. You just need to make sure that your children that were under 18 when you got married to that U.S. citizen. If you're in the United States and your children in the United States and the person that you're marrying is a green card holder, right now visas are current. So technically, you could apply, but you must be in status to apply. And what I mean when I say you must be in status, you must have entered with a visa, number one. Number two, your visa, your entry time should not have expired. You know how like most people get an I-94. When you come in and they give you a timeline, a lot of times it's 6 months. So you can't have overstayed that, if the person petitioning for you is a green card holder. And that would allow you to. Kenny says, when are you available for a consultation in person in Orlando? I don't know. You can check my calendar. You can either call us to schedule, or you can actually book it yourself online on our website. We're accepting in-office consults now. Now that COVID is hopefully tapering, you still will be required to wear a mask, but you can schedule an in-office consult. Definitely just check the calendar by booking directly online, or call us 407-995-6567. Somebody says, can one still apply for a visiting visa if they're waiting for a K1 or CR1 petition? I mean, technically, nobody's stopping you from, but the question is, are they going to approve you? A lot of times they may not, because they know that you already have a pending petition, but that's up to you. If you want to apply for a visa, by all means you can. Andrea says, even though the travel document says it's not guaranteed entry back into the country, is it still safe to still travel out of the U.S.? So, I cannot give you guys legal advice, as far as whether you want to travel outside the country, but that is just something that's always listed there. Just the same way that a lawyer will tell you that nothing is guaranteed. There's never any guarantee that any attorney can give you, because, that's life. You can't give anybody any guarantee. You don't know what's going to happen if the person, gets arrested there, or whatever it is, or has a crime, or whatever it is. But generally, if you have advanced parole and you're not in removal proceedings, you're not in any criminal proceedings, you can leave the country and you can come back in. Okay, guys, I think that is all the questions. Let's see. Instagram, you guys are very quiet today. OJ says, thanks once again for keeping us well informed. Oh, you're very welcome. Okay, guys. Well, I hope you guys have an amazing weekend. And I will see you guys on Monday. All right, guys, have a good one. Bye.